All right, so let's start. In yesterday's class, we have discussed about part of arbitration, and at least we have discussed until the our discussion was that the arbitration, whether there is any benefit to arbitration or not, and if there is any benefit, what are the exact benefit that comes out with arbitration? And as a legal advisor, what would be your suggestion to your company, to your MNCs, that whether they should go for arbitration or not during the course of their merger and acquisition? So most of you have said that okay, it's fair enough to go for merger and acquisition, fair enough to go for arbitration, conciliation, or negotiation or mediation. So yeah, we're talking about four different fields. Do you notice here? We're talking about four different fields: arbitration, conciliation, mediation, and negotiation. So what do you think makes up a different? Are you going to suggest that okay? Unilever or so and so, so is the name of the firm. Are you going to suggest them that you can either go for arbitration, either go for mediation, conciliation, or negotiation? So, are you going to give a blank check to them, or will you be specific in the matter of the concern? Tell me,
Specific, sir.
specific.
Yes.
So, what you are going specifically to suggest your MNCs?
So it depends. So if
Depends. Okay.
the yeah it if the issue is something like it can be solved through mediation, like the both the parties can come together and they only can solve it, then they can do it. Conciliation is like within the institution itself. So if it's within the institution, then within those MNC itself, then they can go for conciliation. And arbitration only when the like both the parties are not ready to go through mediation and solve it through themselves, they have to go for arbitration.
Okay. So, if they are not willing to solve it by themselves, they can go for arbitration. Uh, to certain extent, I would like to disagree, but more than my vote over here, what's your say that what makes up a difference between arbitration, conciliation, mediation, and negotiation? Guys, what makes up a difference between these four terms out here? Tell me, answer.
So if I can, I mean, I want to just try.
Sure, sure.
So mediation and negotiation means there'll be a mediator who is a neutral party to the proceeding, and they won't tell the solution, or their thing will not be binding, but they will help the parties to come to a mutual ground or a compromise kind of thing. But in arbitration, there's a neutral party and an independent party which will declare who's an arbitrator basically, who will declare an award, arbitration award, and it is binding on the parties. And when it comes to conciliation, I think it is something which happens within the company itself. There is, yeah.
All right. So you also see that there is a chance of improvement in the answer. The last pause indicated that. Okay. So see, basically difference between arbitration, conciliation, mediation, and negotiation. When you're talking about that, what particular field would you like to suggest to anyone in the course of merger acquisition or after the merger acquisition deal has done and then there is particular dispute or such other dispute? What would be your suggestion? See, answer to this particular thing is not as straight as it seems. There may be differences arise, and there may be chances that your deal may lock up in the wrong room. If there is chances of mediation and you are suggesting arbitration, it may lock up in different room, which means that it may exceed the chances of getting right decision. Not only that, it will chunk up the money. It will burn up the money that you would have used in the marketing or development of your firm, R&D work. So it is always suggestible that you choose the path that seems to be at least a close, that closes the door of any further questions. So that would be that. You see, arbitration is a matter which particularly deals with commercial disputes. So first of all, you need to look at whether the party or the dispute is commercial in nature, right? That will lock up the question. Now, let's say the dispute is commercial in nature. Still, if the dispute is commercial in nature, we won't be looking for conciliation, because conciliation matter is service matter, right? So we'll eliminate conciliation. Now what? We have three suites in our plate, that would be arbitration, negotiation, and mediation. Now you'll see that whether the procedure requires more of a formal procedure, more of a binding procedure, more of a procedure with authority, where you want a proper implementation with the proper terms, it would be arbitration. Where you want a friendly gesture, where you want to jot down the point, where you want to solve the issue without involving so much of money, without involving so much of formal procedure, it would be mediation. Where you want none of the legal authorities to be there, you just want that it's a small issue, it's a day-to-day issue, and we could do it by ourselves also. So that would be negotiation. So if you look in the bottleneck formula, where end of the bottle is the biggest of the circumference, and starting of the bottle is of the smallest of the circumference. Negotiation would be arbitration would be that place. Arbitration will hold that place where there is very little chances that you will come out of it without having the issue solved. But yes, you'll burn up your money, you will burn up lots of your capital, and yes, in the cost of burning up your capital, you will resolve the issue. So it is important to determine that what is the importance of the issue. If it is day-to-day activities, if it is day-to-day fall down, you may ask for mediation, or in a negotiation, or at most mediation. But if it is a formal issue where you require a formal procedure, where you require certain thing to be done in your way, it would be it would be what do you think it would be?
Arbitration.
Arbitration, right? So here we have come up that now we know that in the case of necessity, in the case of circumstances, we could at least suggest to our MNC what kind of dispute resolution mechanism they would choose. Now we are in the circumstances that we will look forward to each of them, so that we may take a prudent decision. And in the module that we are reading, this is a negotiation module. So when you get the certificate course, you will get a certificate course on arbitration and mediation in the merger deal as well. So that will add a value in your course, because not all the law students go through combination of these, and not all the teachers knows about it, because they're not in corporate structure. Since we are into corporate structure, we have been into the process. We feel that this is prudent enough to impart the knowledge that is required on the field, and not only on the theoretical portion. Now, kinds of or types of arbitration: you have ad hoc arbitration, you have institutional arbitration. See, ad hoc arbitration, as the name suggests, is the arbitration where a point of dispute or point of procedure has not been determined. Right. In ad hoc arbitration, you can choose your arbitrator. In ad hoc arbitration, you can choose the place of arbitration. You can choose the term of arbitration. You can choose in whatever method, in whatever manner the arbitration is to be conducted. Right. That is ad hoc arbitration. Now we are talking about institutional arbitrations. Institutional arbitration are those arbitrations where the terms and place and everything like that is determined by the institutional arbitral institutions, and all you have to do is to take up your advocates, jot down the issues, and then determine the number of arbitrator, and thereafter the playground for you will be settled in the institutional arbitrations. However, in ad hoc arbitrations, you have to decide on everything, whether it is place of arbitration, whether it is who should be the arbitrator, whether it is for the procedure of arbitration. Do you get the difference between ad hoc arbitration and institutional arbitration?
On him. I was too distracted the whole time.
Do you get the difference?
What do you mean? Why?
Guys, wake up.
For the guy.
So can you repeat?
Sure, I can.
I mean, I understood it, but in institutional arbitration, uh, there is no chance of any, changes that the parties can make.
What's that? She has to wine and dine.
Yes, moreover, the things are determined. Things are predetermined in institutional arbitration. And in ad hoc arbitration, it is the party who will determine everything. See, I'll tell you this, and then you'll get it. Since arbitration is in picture from 1996, and there have been several amendments such as Amendment 2015 and 2018. Now, after these amendments, importance to the arbitration has permanently increased, and now and then justice and the court and Supreme Court has been stressing importance of ADR mechanism to resolve the dispute. Why? Because there are lots of cases pending in the judiciary, and it is nearly impossible to solve each of the cases, right? So that is why they are stressing on arbitration mechanism, not only arbitration mechanism but entire ADR mechanism, right? Whether you are talking about ODR, online dispute resolution, or you are talking about ADR, or alternate dispute resolution. Now, after 2018, each high court shall have their own institutional arbitration. I mean, high court will be the body who will be constituting, or at least making up the, make sure that they, some institution have joined their hand and they'll be acting as an institutional arbitration. So in this institutional arbitration, what happens that the institutions such as, if you say Indian Arbitration Tribunal, right? This is and there are several other arbitration tribunals, FICCI Arbitration Tribunal. There are several other arbitration tribunals, right? So they have their determined advocates with them. They have their determined arbitrator with them. Obviously, you can choose. You have the right to choose, but in institutional arbitration, most of the points has already been decided by the institution that is actually playing as organizer, right? Someone is organizing it for you, and then you have a playground ready for you. That is institution, ready-made food. Now you can also make a food in your kitchen, the best food possible, right? So in those circumstances, what you will be doing, that you will be asking for ad hoc arbitration, because then you can add up your ingredients, then you can add up your things to get the best product out of your hands, right? So ad hoc arbitration is result of your own, choice, in your own decision, and institutional arbitration, most of the things depends on the organizer. Do you get it?
Yes, sir. Thank you.
Perfect. Mediation we have discussed, so we'll skip. Now this point we have also discussed in the last class, that what is the importance of section 7 and section 8. In section 7 you are looking for the arbitration agreement. So there should be arbitration agreement before conducting the arbitration. And once arbitration has been, once there is arbitration agreement, party under section 8 may refer to the court for arbitration. They'll refer the matter to arbitration. So that we have discussed in the last class itself, and we have discussed in very length. Now, kinds of arbitration we have also discussed in the last class: domestic arbitration and international arbitration. So we'll skip. Now I'll tell you for fast track arbitration. That's there in section 29B. Right. So fast track, see, there is two section over there. Section 29A and 29B. 29B was last amended in 2015. Right. So this particular section, see, basically when you are talking about arbitration, you're talking about the time frame. You'll at the maximum of which you'll conclude the proceeding in 12 months. And if you want extra time, that will be given, and that time would be 6 month extra. So total you'll be investing 18 months of time to get an arbitral award, not more than that. Now talking about fast track arbitration. So in fast track arbitration, the arbitration has to be concluded within 6 months. The matter should be concluded within 6 months, right? So to reduce this time frame, what parties are doing, that parties are eliminating all the oral arguments that will be going through the arbitration, right? So what they are doing is that oral argument, they are eliminating it. There is no need to go for oral arguments. All you need to do is to come up with the documents, submit the documents, and whatever will there be based on the documents, the party, the arbitrator will reward or make a award based on the evidences that is before it. So that's the difference between institutional arbitration, arbitration and fast track arbitration. Section 29A and 29B. Do you get it? Do you get it?
Yes, sir.
Yes, sir.
Now, these things are quite in detail. That composition of arbitration, you don't. I mean, it's not that you don't need to know, but this is not related to the course. I mean, this will be a too much of detail in this particular act, so we'll skip. All I want, see, my intention of going through these provisions was basically to give you an idea that what is arbitration, what is conciliation, what is mediation, and how it works, so that in the case of necessity, you may take a prudent decision. No, right? Because this is not as a legal advisor. This is not your thing to be there in the arbitration. However, a party may ask you to be an advocate in arbitration also, be an advocate in negotiation and mediation disputes also. So that they can do as the VC does to us, that they'll ask certain tasks which is not in a regular course of work, but they may ask teachers to do so, and we'll have to do it. So likewise, they may ask you to be there, in the executing of the proceedings. For that, you need to know about arbitration, entire ADR mechanism, and particularly Arbitration Conciliation Act and Mediation Act 2023, right? So that will be there. You may number of arbitrator, as we have discussed, that you need to take odd number of arbitrator. Odd number, why? Because let's say there are two or even number of arbitrators, so the chances that the arbitral award may be distributed on the 50-50 judgment, and that is not required at all. I mean, see, there will be a 50-50 sharing of the award, which means that the award cannot be executed. And so to make the award to actually execute the award, what you need is to what you need is basically a number of arbitrator, that even if the chances of 50-50 distribution of the opinion, one shall give a paramount decision, which is number which with the number you will get in odd number. Appointment of arbitrator is there in section 11. Right. As we have already discussed, that parties in the proceedings may appoint the arbitrator, and both party has to be ready they have to be ready. They willingly, and they will appoint the arbitrator with the consent of each other. Each party has to appoint one arbitrator, and then third arbitrator will be appointed by the arbitrator who is already been appointed. So that's how it works. Qualification of arbiters is basically that one need to be experienced person. There is a long list of qualification that is there in section no schedule 8, and it is also important that there shall not be any connection of the arbitrator with the parties. The long list of connection has been given in schedule 5 and schedule 7. You may read it for your own good that what are the limitations of arbitrators under schedule 5 and under schedule 7, right? So I believe that you'll go through after the class. Will you?
बेटा 9 कपड़े थे 45 रुपए हो गए 30 हैं 15 तेरे बाकी रहेगी
70 देने
Now, ground of challenge and challenge procedure. So, ground of challenge you'll see in section 34 basically. Here is that if there is any connection between the parties and the arbitrator, as I have discussed under schedule 5 and schedule 7. So that would basically be the ground of challenge. And apart from those, there is a long, list of challenges that we will see in section 34. But before going through section 34, we'll also need to see we also need to see that whether
सही है बेटा 13 ही थे कपड़े
yeah
और
whether one should go for interim maintenance or not.
वो 75 बैठ
Sir, we can't hear you.
Am I audible now?
Yes, sir.
Manoj, there is some voice coming from your side, so kindly mute yourself and check that whether the system is on mute or not. So, see, we'll be discussing about arbitral award and the ground to set aside arbitral award under section 34. But that we'll do tomorrow. Today, we'll discuss about section 9 and section 17. Section 9 and section 17. So under section 9C, you can go to the court to get interim relief, and in the court, basically you will reach before starting of the arbitration. Before starting of the arbitration and after arbitration award has been declared, you may visit the court. And in the course of arbitration award, in the course of proceedings, what we will sort for, we'll sort for section 17. Section 17 basically talks about the provision where he'll ask for interim relief during during the proceedings of arbitration, and he'll ask you before the appellate tribunal. You'll get the difference between section 9 and section 17. Do you get the difference between section 9 and section 17?
Sir, can you please repeat?
See, under section 9, before starting of the arbitration tribunal, if you want certain interim relief from the court, you may visit the court, right? Or even after completion of the arbitral tribunal, even after completion of the arbitral award, but before the execution of arbitral award, there is a time gap of 3 months before execution of the arbitral award. So before execution of the arbitral award and after the arbitral award has been pronounced, you may visit the court. You may knock the door of the court so as to get interim relief. interim relief can also be granted during the proceedings of arbitral tribunal, and that you have to sought before arbitral tribunal itself, and that is there in section 70. Do you get it?
Yes, sir.
Perfect.
Yes, sir.
Perfect. Substitute arbitration termination of mandate of CM is keeping certain portion that you may have noticed by now. That is voluntarily, and that is because to save you, because that will be very lengthy. If you go into arbitration, in detail, that will take a longer time. It will take more than a month, and we have to have made these 200 some slides for arbitration only. So that is why we are sitting to make it important for your course, so that you may get the maximum advantage out of the course. At least an idea of arbitration and mediation is complete, so that you may accordingly take the decision. Now, severability of arbitration agreement. What does it mean? Basically that, see, as we have discussed in under section 7, that you can sort for under section 7, there is that there shall be an arbitration agreement, right? So what if your contract, the arbitration dispute is based on the contract, and what if your contract is null and void? If the contract is null and void, would your arbitration award or arbitration tribunal will become null and void,
Yes, sir.
right?
No, sir.
If your contract is null and void and based on which arbitration agreement has been made, so if the contract is null and void, would your arbitration tribunal will also be null and void?
An arbitral agreement, a particular clause can never be void, because the reason is that arbitral clause can be put before or after it has happened in the agreement itself, or after any dispute has came into picture, and then a step is taken that we need to go to arbitral tribunal. That's the reason that is called the doctrine of severability, which means it has a different and whether even if the agreement is void, it is not void. The clause.
Correct. Oh, I cannot see more correctness in this answer. Correct. See, the separability of arbitration agreement basically means that even if the contract is null and void, even if there is no implication of the contract, the arbitration agreement remains alive. Right. Why so? Because otherwise, see, in the tribunal also there is several matters that will be discussed, and contract is a very small part of the arbitration agreement. Right. Even if the dispute arises out of contract, there are other clauses, there are other materials that is also in the display. So let's say in the course of time where other matters are to be discussed and the contract is null and void, and it would, if it would make the arbitration tribunal also void, so it would be very difficult for a settlement to be reached. Second thing, that even after the null and void of the contract, the settlement will be respected in the arbitration agreement, right? And anyway, we have a doctrine of severability, which means that arbitration agreement will be a different agreement, and that is there in section 16. So it is from the it makes it power from the statutory authority itself. Do you get it?
Yes, sir.
Perfect. Consequences, competence principle is basically that also there's in section 16. It is basically that each arbitral tribunal has its own jurisdiction, right? So it is talking about basically jurisdiction, that if the arbitral tribunal won't have any jurisdiction, which means that it cannot call up the party, it cannot call up the party for making evidence or delivering the evidence, right? It cannot summon the party for anything. So it has its own jurisdiction and it may act accordingly. So that is basically the concept of competence, and that is there in section 16. Now, section 17, we have already discussed about interim relief. Section 9 and section 17, we have discussed earlier. Conduct of the arbitral proceedings, rules of procedure is important for you. Now, determination of rules of procedure. See, section 9 basically says that civil procedure code is not applicable. Right, a civil procedure code 1908 is not applicable, and neither is 1872 Indian Evidence Act is applicable. So, what does it basically means is that under section 23 clause 1, a party will form its own procedure to to file a claim, to file a defense of the claim, to file a counter claim, and so. It is not that you require CPC or evidence for that. The party make form its own procedure, and in the absence of any procedure, the act that will be followed is Arbitration Conciliation Act 1996. So basically, it talks about that. So it is obviously very much important in negotiation round. Place of arbitration can be determined by the party, as we have already discussed that whatever place will be decided by the party, that will be there. Seat of arbitration is place of arbitration only. Now, section 23, as we were discussing, it basically talks about claim, counterclaim, set off, and amendment. So, what is claim? Claim is basically a document that you present before a tribunal in which you ask for your right. Right. Amendment is basically making some changes in your rights in a document that you call as claim, making some changes so as to make it more substantive. Counterclaim is that counterclaim and set off is more of a similar. Counterclaim is when you ask to settle the amount that is been sought by sought with the claim, and counterclaim is basically that you are making up a claim in counter or in respect to the claim that has already been made. What I'm trying to say is that let's say a person has made a claim of 1,000 rupees. Now, if you are asking to settle anything below 1,000 rupees, right, that would be your set off. If you are asking some claim that is above 1,000 rupees, that would be counter claim. Do you get it? It is as easy as that. Do you get it?
Yes.
Should I explain it again? Basically, lots of law students make a confusion between counterclaim and set off. So set off is when, let's say, if the claim is of 1,000 rupees and you are asking anything below 1,000 rupees, that would be set off because you will be setting off that amount. Let's say claim is of 1,000 rupees, you are setting it off. You are setting 100 rupees off. So it would be the set off would be of 100 rupees. So all you need to give is 900 rupees. Or let's say 1,000 rupees the claim, you are making a claim, you are making a claim of 1,000 rupees in equal to that, that would be set off of 1,000 rupees. Now counterclaim would be anything above 1,000. That is, let's say if your claim is of 1,000, you are asking for 2,000, 1,000 rupees would be a counterclaim. Do you get it? Simple math.
Yes.
Perfect. So we have discussed that counterclaim set off in very detail. I mean, not in detail, but at least you could understand it. Hearing and written proceeding. See, under section 24, it says that if you want, if both the parties want, they may set aside hearings, oral hearings, and go for documentary evidence. Otherwise, uh, oral hearing, there'll be a oral hearing by default. Now, if you talk about fast track arbitration, we have already discussed that under section 29B. In fast track arbitration, oral hearing is excused, which means that you won't have to come up with oral hearing. Do you get it? So that's there. Default of the party. export, section 26 and 27 is important, and we may discuss it. So while section 26 talk about expert, witness, calling up the expert witness, and that since under section 16, arbitration has its own competency on jurisdiction, so it can make up the claim. It has a jurisdiction to do so. Under section 27, it is very important that you may ask for the assistance of the court, right? Let's say if someone is making a false claim or coming up with false evidence, or making up a false statement in before the arbitral tribunal, since arbitral tribunal don't it won't have any power as the court, it can't punish someone for contempt of arbitral tribunal. All it can do is to file the proceeding under section 27 clause 5 before the court to to get the award, to punish the person who is making a false claim, to get the right evidence, to summon someone to deliver the evidence. So section 27 makes up a very important point in the arbitration. It basically, see, there are two sections that connects you with the court during the arbitral proceedings. That is section 9, where you can ask for interim relief, where you can ask even before or after the concluding of the arbitral tribunal, you can ask for interim relief. Under section 27 clause 5, you can visit the court so as to ask for the evidences, so as to come up with the evidences, so as to verify the evidences. Not only that, you to punish who is sovereign making content. Do you get it? Section 29 we have discussed. Now, arbitral award, which is there in section 34, this is very important, and here we'll end the arbitration. We have some time, but I'd like to discuss it tomorrow in the class, because it will take time. Also, it is important, right? So I don't want to just keep it like that. We will discuss about arbitration award, and then we'll complete arbitration. We'll start with mediation and negotiation, and we'll also try to study strategies of mediation and negotiation. Right, so let's discuss this in next class. Okay.
All right, sir.
Thank you for the class, and see you tomorrow.
Thank you, sir.
Thank you, sir.